With much enthusiasm, various petitioners and homosexual couples, went to the Supreme Court of India demanding marriage equality. They indeed are disappointed today because the Supreme Court has refused to grant any kind of legal recognition to homosexual couples. They can still live as couples. It's a free democratic country, but there is no legal sanction or legal protection to their relationships, at least as of now, unless the government of India comes up with a statutory framework or implements a special set of rules that recognizes these partnerships. While there was a much needed discussion that happened across the country in the judicial corridors and outside, people familiar with the family law space would recognize that it was almost an impossible task for the Supreme Court to recognize same-sex marriages in the existing legal framework. The family law sphere, which is dominated by personal laws, and the so-called secular laws are only far and few. Say the Special Marriage Act, which also has gender definition, or the assumption of a man and a woman when they talk about the institution of a marriage. What is rather interesting is that the religious laws like the Hindu Marriage Act, the Christian Marriage Act, or various other laws that have codified the personal law space are also something that would be amenable to changes had Special Marriages Act been changed by the Supreme Court of India. The larger point that I'm trying to make here is that if the Supreme Court had decided in a scenario, the larger point that I'm making here is that had the Supreme Court decided to tinker with the Special Marriage Act, or the reason why they have decided not to tinker with the Special Marriage Act is that it inevitably would have affected the personal law. Now, this was an argument that was vociferously made by the central government that you cannot touch the Special Marriages Act without really touching upon the sphere of the personal laws. 99% of marriages in our country are governed by the sphere of personal laws. The moment you recognize a marriage under the Special Marriage Act, you will also have to rationalize the laws around divorce, inheritance, adoption, and various other facets. The fact that there were over 100 laws that needed to be rationalized was a mammoth task that the judiciary cannot undertake. The second and the most important thing is that India, unlike any other democratic nation in the world, does not have the regime of a uniform civil court. Imagine a scenario where you don't have to countenance with the possibility of a Hindu personal law, a Muslim personal law, or a Christian personal law, and there is a civil rule of, a civil statute that exists that governs the sphere of the family law. That would have been far amenable and open to change. But the present scheme of family law in India, and I'm reading together the personal law space plus the Special Marriages Act and the codified laws like the Hindu Marriage Act. It's a complicated sphere right now. It needs rationalization, it needs simplification. We also talk about a uniform civil code which should come up at some point in time. But without the rationalization of the present legal framework, any kind of judicial tinkering, any kind of reading into the existing statutes would have only created far more mayhem and confusion. The court couldn't have done it. It's a legal impossibility. What is rather open is to the central government. They must consider all the concerns that the community has voiced and the Supreme Court that they have mandated and come up with solutions or a statute. But it's only the government of the day that can bring in a new law. There was nothing that the court could have struck down, like a provision in the Special Marriages Act. They couldn't have declared marriage as a fundamental right. And the third and the most important facet, anything could not have been read into the present scheme of laws. Whether it's marriage, whether it's divorce, whether it's inheritance, succession, or any other facet, it presumes the existence of a man and a woman. Nobody debates about the fact that these presumptions need to go for us to have a more open and equitable society. But the most important part as to how do we achieve that equity is yet to be answered. The court could not answer it today, but hopefully in the times to come when we have more rationalization of the personal laws in this country, only then we'll be able to answer all these questions.